moving on, consensual principle. According to the principle of consensus, an agreement is reached at the moment agreement is reached. We know this already. We talk about several principles of an agreement. According to the oldest doctrine, it must be firmly held about the existence of a conformity of will between the two sides. This is talking about the importance of meeting of minds. When the will is at odds, an agreement cannot be cannot be reasoned. I think that's the issue. Statements that should be considered to give birth to the intention of the person who wants to bind himself. Statements that should be considered to give birth to the intention of the person who wants to bind himself. So I will move to the next slide. It's about offer and acceptance. I think this is the essential things that I want to discuss today. About offer and acceptance. We talk about agreement, we talk about consent. But in real life situation, sometimes there will be a gap between an offer and an acceptance. Let's say, for example, if you want to buy something, you are in the mini mart, everything is clear, the price is clear, right? When you bring the goods to the cashier, it is already meant that you intend to purchase these things, right? So it will be easier and it will be faster to have a consent. Both parties consent that one is going to sell, one is going to buy. But in so many situations, it might not be like that. Sometimes there will be a gap. Let's just use my example as law firm. I have an office, and then not every time I meet with a client at my office, or they will come to me all the time. It's not like that, right? Well, before pandemic, it is quite normal like that, but now it's almost very different, right? So we can meet in my office, or I can meet to the client's office. We can talk about what we can do as a lawyer, as a law firm, what legal services that I can provide. And then this prospective client will let me know what they need from us. That perhaps, let's say that they have issues on labor. That's why they need a lawyer to review an agreement, labor agreement, or they would like to have assistance in dealing with the labor dispute. So many things can happen. Mergers and acquisition services, due diligence services. Okay. So most of the time, the client will call me. They will tell me about their issues and problems, right? And then I will briefly explain what we do, what we can do, what we cannot do. And then most of the time that the prospective client will say that, okay, Pak Eddy, please send proposal to us, right? So that proposal is heavily related to this, what we are discussing, offer and acceptance. So the proposal, in my case, I will normally send my proposal through an email first, because my proposal is quite thick if I have to print it, or if I have to send it through email, scan copy, it's quite many. Yeah, it's almost 20 pages. So that's why I always focus on the essential commercial terms. Essential commercial terms, yeah. So when I send my proposal through an email, this is the first time, yeah. This is the first time. Let's say after discussion through phone, then I send a proposal through an email. I will focus on the scope of services. So what is required that I have to do, right? And then the legal fee for that. And then the legal fee is to be paid in that amount, excluding everything else. And then sometimes the time frame of the work, yeah. And what is not considered as scope of service, yeah. What is not included, what is included, and what is not included in the scope of service. So the clients will then reply. Yeah, the client will then reply and then perhaps giving okay immediately. Yeah. Or they might say that they will have to discuss internally. Okay. Because corporations having hierarchy internally, so they have to talk about it with their partners, with their executives, with other persons, yeah. And then they will reply whether they are fine with it or they have something else in their mind, yeah. Perhaps they want to expand the scope of services, or they want to get a discount on the legal fees, right? So that's offer and acceptance, yeah. My proposal can be considered as an offer. Yeah, my proposal can be considered as an offer. So I offer it first. I offer because I am invited to send a proposal, right? So I offer my service and my price. So again, as a lawyer and as a businessman, we normally will focus on the essential commercial terms, right? Like I said in my proposal through email, I only focus on several items, yeah. But when it is agreed, I will also outline all the other items, yeah. For example, like payment terms, terms and conditions like confidentiality, what happens if there is a conflict, if there is a dispute between the parties, yeah. So it's other than commercial essential terms. I will also include it in the my offer document, and then when it is accepted by the prospective client, then this will be binding as an agreement. So that's the offer and acceptance, yeah. We don't really analyze it sometimes, yeah. Even I when I'm doing this kind of, well, I've been doing it for more than 12 years already, yeah. Sending proposal back and forth, yeah. I'm not really thinking it as an offer and acceptance, yeah. But it is, yeah, it is an offer and acceptance. So that's why we will look into some of the items in here. So there are interesting legal doctrines, yeah, because the Indonesian Civil Code does not really discuss this in details, right? They don't really discuss it in detail unless the discussion related to the defective will. But other than that, they don't really talk about offer and acceptance, yeah. And sometimes people say that the offer and acceptance mechanism is not known under Indonesian Civil Code. No, it is not like that. It is still known. It is known. It's part of the agreement. So according to the common doctrine, the agreement must be considered born or risen or occurred on the party who made the offer, the offeror ya kalau in English, offeror and then offeree, received the answer contained in the letter, because that second also detik itu ya, can be considered as the birth of the agreement. Who made the offer received the answer. So the offerer receives an answer from the other party. Because that second can be considered as the birth of the agreement. The residence of the party making the offer applies as the place of birth or closing of the agreement. So you can see it here that the time and location, right? The time and location of formation of an agreement. So when it is formed, what time is it formed? And where it is considered formed. So the timing is important because we have to understand whether there is an agreement or there is not yet an agreement, right? Whether an because if there is an agreement, then the parties are bound to fulfill it. If there is no agreement, no obligations. But if there is agreement, the parties are bound to do what is required under the agreement. That's the timing, but also the location. The location is important. Why? Especially when the deal is made between Indonesians and foreigners. If between Indonesians, there will be problems where the dispute will be filed if there is a conflict between them. But that's nothing compared if the example is between Indonesians and foreigners, because between Indonesians and foreigners there will be conflict of law. It's not only a conflict of district court or location of courts, but conflict of law. But in case of Indonesians, even though the location of agreement is not determined or is not clear, the HIR, our civil procedural law, is already clear that when the claim has to be filed, it will be filed at the defendant's domicile, right? So there will be not an issue anymore in terms of Indonesians with Indonesians transaction or Indonesians among Indonesians dealing. But when Indonesians deal with foreigner, there will be conflict of law. And in here, under the doctrine by Professor Subekti, that the residence of the party making the offer applies as the place of birth or closing of the agreement. The consummation or the commencement of the agreement. So if the offerer is Indonesian and the party receiving and accepting the offer is foreigner, and Indonesian lives in Indonesia, the location of the birth of the agreement will be considered in Indonesia. So offer and acceptance, the only, I think, one of the author that is really discussing in quite detail, actually in a very detail compared to other writers, is only J. Satrio. I think I also saw some similarities with other authors, yeah, but nothing compared to J. Satrio. So if you look and read his book that I mentioned in the early of our session, only J. Satrio actually having very detailed information about offer and acceptance and the related theories. Yeah, we will talk also about the theories in here. So an offer is different than tender. Yeah, tender is offering of money actually. Yeah, so tender is I will need to do something. I will have a project. I invite you to submit your offer. Yeah, that's tender actually. So an offer is submission of an offer. Yeah, you really do an offer. There is a principle that an offer can be revoked as long as that offer has not been admitted by the other party. Yeah, so there is an offer and then there is an acceptance. Yeah, it's through communication. It's through communication. It's through some actions. Yeah, we will look into it step by step. So if I submit an offer, I can change my mind. I can change my mind, right? I can change my mind, or I realized that I was wrong. Perhaps the scope of service that I wrote before in my proposal is less than what is expected by the client, or even too wide than what is expected, or the legal fees. Perhaps the legal fees I considered it's too much. It's very seldom that I did that, but or the legal fees are too less actually. Yeah, let's say I should charge 200, but I charge it only 100, for example. So when I submit an email, like I said, I always do it in email first. It's very rare that I send immediately a proposal in writing, yeah, in complete form. Normally I will send just through email, and it happens sometimes actually, yeah, maybe 5 times through these 10 years my activity as a lawyer, maybe even more. Yeah, I don't really remember, but it happened. I remember that it happened. I changed it again. I sent a follow-up email after my initial email. I sent to clarify again that this is what I meant. Or or sometimes I just send a proposal, and then the client has some questions about that proposal, right? Would like to get some clarification about this point, will this mean like this, will this mean like that? And then I realized that I did something wrong in my proposal, in my previous proposal. I was not very clear about this, I was not very clear about that, or I was not very clear about the legal fees. Yeah, sometimes like this. For example, in my dealings as a lawyer, I will charge based on the scope of service only. Yeah, so the scope of service must be definite. It cannot be not clear. Yeah, so it has to be clear. And sometimes the client would like to have some like a regular advice that any problems that they face, they will come to me and ask my advice. Now, there might be a situation when I forgot to insert in my offering statements like, okay, I can help you in the regular advice, but this scope of service will not be considered, including the assistance on litigation, for example, the assistance on arbitration, the assistance on criminal investigation. Well, it is important to do it, right? Because this is the client will the client's expectation from the beginning is that they can come to us any time they have a problem that they have to face. So perhaps from the client's point of view, it can be anything. While in my point of view, it cannot be all the thing, right? Because I cannot do all things with one a legal fee that is already decided, agreed by the parties. So sometimes it happens, and then I have to follow up again my email. Okay, this scope of service excludes blah blah blah, ya, tidak termasuk blah blah blah. So then it becomes clear. So going back to this, when you do that, life is still easy, yeah, because the other party hasn't admitted, hasn't accepted your offer. The problem will arise if you are late in changing your offer or in revoking your offer. And you know what? I have my own experience. Before I showed and explained about how I changed my offer. Yeah, I sent an offer and then I realized it was wrong, so I changed it. And most of the time it was before the acceptance by the client. Yeah, because when it is accepted, it's an agreement already. Yeah, so I cannot do much, right? Even though I want to try to change it, it won't be good in my client's view, yeah, because it's not like a gentleman. Yeah, well, it's agreed already. Let's just proceed what we have to do. So it's very. I never touch my engagement that has been agreed. But as long as it hasn't been agreed, then I will tweak this and there. And in fact, talking about revocation of offer, yeah, revoking an offer, it happens perhaps you only several times also, yeah, just like when I change the offer, even in here, revoking is, of course, a lot less, yeah, than changing the offer, yeah, because revoking is you pull back what you sent out, right? I mean, you fully pull back what you sent out. So it's like, okay, I'm requested to file to send a proposal. I'm sending my proposal and then I'm pulling it back. Yeah, that's the revoking an offer. I'm pulling it back. And when did that happen? That happened when there was a client calling me someday, and they are having a business in logistics, I think, in Indonesia, and this is a startup with application. And they said to me they are new, so they cannot pay much for the legal fees, yeah, but they would like to cooperate with our firm, blah 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 blah, and what is it? Talking, saying things to me that they want the work to be fast. They want the lawyer to listen to them, blah 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 blah. Yeah. Well, hearing the their explanation at the time through telephones, yeah, it's quite well, like I was feeling not comfortable, actually. Yeah. I don't know why. Well, it's not all the time. Yeah, a client comes to you and then they put out so many things that they want the lawyer to do, right? But I guess let's just give it a try, right? Give it a try anyway. This is I think it's a good company. It's prospective company, so why not? So I sent proposal to them, right? I sent proposal, and you know what happened? I sent proposal, and this also in my engagement letter, my complete form of engagement letter, like I said, yeah. Normally I send through email only the essential terms, but sometimes also with the draft of engagement letter, the fully complete form. No news, right? And then perhaps 1 week or 2 weeks later, they referred to me and revising and commenting on so many parts of my engagement letter. Yeah, so many you cannot imagine. Even the simple thing they commented on that part. Yeah, this is crazy, man. I mean, you know, the legal fee is not much, like what they said. They cannot give much legal fee. So, well, I said it's fine lah. Let's just proceed. And then before the agreement is reached, yeah, they commented on my engagement so many things that have never been discussed by my other clients. Can you imagine that? Well, I have been practicing for more than 10 years. So most of my clients have not commented any of all my engagement letter. And you can imagine, yeah, small clients, big clients, even very, very big clients, they rarely comment or asking me to revise my terms and conditions in my engagement letter. And this is a startup company. They comment so many things that I really don't have time, you know, to look into it, to understand their comments. I don't have time for that. And I don't want to spend my time doing that. So do you know what I did? I talked with my partner. You know, this is not something that we can accept, yeah. This is revoking an offer, yeah. So I sent an offer. They comments on so many things on that offer, right? And then I said, okay, I withdraw my offer. And that's done. They don't come back anymore to me. I'm happy because I don't have to spend my time just dealing with something that is standard form, okay? This is a standard form agreement, yeah. That's why standard form agreement is important in business, yeah. We cannot say that standard form agreement is violating the law and everything, because it's important, yeah. I have my engagement letter, it's a standardized form, just follow it. Any substantial issues I can discuss, but not really non-substantial, right? I don't really want to discuss it. So I withdraw the offer. Well, you know what? I think that's the first time in my practice as lawyer, because of course we don't want to withdraw our offer, right? We want our offer to be accepted, and then we get paid for what we do. But this time I have to do it, and I did it, and I'm happy after that, yeah, because I understand that. Well, sometimes we just have to choose to whom we do our business dealings. Yeah. Sometimes we cannot do it with everyone. So that happens. I withdraw it. So this talking about withdrawal of an offer, yeah, revocation of an offer or withdrawal of an offer. That will be the same. So the offer is cancelled. An offer is no longer valid if the offeree and the offered dies prior to admittance. Admittance meaning penerimaan, ya. Jadi penawaran, penerimaan, ya. Sometimes I translate it to acceptance, penerimaan, but I think it's easier to understand when I translate it as admittance, ya. Diterima, the offeree and offered dies. The offer is not admitted within the determined time frame. Now, this is also important, yeah. This is also important. What I mean is, there might be a situation where your offer is considered unlimited, because in business transaction, our offer is communicated through mostly through written form, yeah. Initially through verbal form, talking, but then after that it has to be in writing, right? So my offer, it's good to limit it, yeah. You can say that penawaran ini berlaku hingga, ya, atau penawaran ini hanya berlaku selama. Ya. So this offer is only valid during, yeah, for the duration of, yeah. So there has to be limit, yeah, because if it is not, well, if you look into J. Satrio's book, he said that unlimited offer is not reasonable, even though there is an argument about it, yeah. Even though there is a debate between scholars that there might be considered like unlimited offer, but Satrio said it is unreasonable. But again, just going out of this argument and debate, I think we can learn something from this, that when you send an offer, there should be a time frame. Yeah, there should be a time expiry when it will be expired. Yeah, because like me, like myself as a lawyer, let's say I offer my service for 100 million for this kind of work, but then 5 years passes, right? I sent my offer 5 years ago, and then the other party said, okay, I gladly receive your offer 5 years afterwards, right? Well, 5 years afterward, my legal fees has become 500 million, let's say. So it's 5 times. So of course, I don't want to be bound with the 100 million, right? Because this is 5 years afterward. That was 5 years ago, right? But it's a good thing for him. Perhaps he already knows that my fees is 500 million now, and he received my previous offer for 100 million. Then he tried to get that. So yeah, that is that is why I think we have to limit our offer. The offer submits conditional admittance. On that case, that will be considered as counter offer. Nah, this is another thing. This is like conditional admittance. Yeah. So this is like a counter offer. Yeah, that is correct, I think. So when there is an offer, yeah, there is an offer. One party is offering something. Like I said, like I explained before, my clients sometimes comment on my offering. Sometimes they just want to have a verification, or sometimes they said to me like this, Pak Eddy, will this scope of service will include meeting with our teams? I said yes. Will it be limited? They asked again. No, it's not. It's unlimited, but of course it should be it should be done when it is necessary to do, right? If we don't need a meeting, why should we have a meeting? But if it is necessary to have a meeting, of course it is included. But then they ask again, does it also include meeting with our counterpart, our business partner? No, I said. If you want us to attend meetings with your business partner, we will charge additional fees, right? So on that, after that discussion, after that verification, my prospective clients will ask me to insert in my engagement letter the thing that the scope of service includes meeting with clients' teams. Yeah, so that's the counter offer. Yeah, they are countering my offer. That's on the terms, on the conditions. Yeah, syarat-syarat dari engagement letter yang dia counter kan. But sometimes they counter the price, right? They counter the price. Perhaps let's say I ask for 100. They ask a discount for 80 or for 75. Or they ask for 100, they ask for 75. I'm asking for 100, they ask for 75, and then they said the payment terms has to be revised. Yeah, because in my normal dealing, I will ask my client to pay 50 in advance, 50 afterwards, after it is done. Yes, 50 in advance, 50 after it is done. But sometimes my client said, can it be 20% in advance and then 30% after it is filed, for example, and then the rest is after it is done. Yeah. So there will be no negotiation like that. Yeah. So that's offer, yeah, my first proposal, and then countered by the other party, and then I can counter it again, right? I can counter it again. Like for example, my last offer with a prospective client, I said that my fees to do this is, they are countering my payment terms. So like I said, I want to do it 50-50. But this guy said, can it be 20-80? No, I cannot. So I said to them, no, it cannot be 20-80. So then they agree with the 50-50. So so you offer, they will counter you, and we have to reply, right? Whether we are fine with it or not. Yeah. But then I said, no, we are not fine, right? I mean, so I decline your counter offer. That's what I meant, right? Saya menolak penawaran balikmu. Ini kan counter offer kan seperti penawaran balik ya. So I decline your counter offer. Meaning, if you push me like that, well, there will be no deal. Yeah, okay. Do you get my point? When I decline their counter offer, it will mean that I don't want it. It must be 50-50. It cannot be 20-80, right? And then they understand that. Yeah, if they keeps on pushing me to agree on 50-50, there will be no deal. There will be no agreement reached. Yeah. So that's why this is important, the offer and acceptance. Even though we don't really think about it, it just happens like that. But this is the case. That's why we need to talk and understand about offer and acceptance. Yeah, because when there is no deal, there is no agreement, no obligations on my side. Or an offer is no longer valid if conditions of offer are not fulfilled. Yeah. Well, this is not. I have another example on this. There is also interesting actually, because it is even disputed later on, and the other party goes into court, and this about offer and acceptance thing is still discussed in the court. Well, that's very interesting. So what happens is, the parties have a contract, right? The parties have a contract, and then in the contract there is a clause, a clause saying that if there is a conflict between the parties, any party or the parties, I don't really remember the exact wordings, but any party or the parties can go either to the court or to the arbitration. That is the clause. So it's confusing, right? So when there is a conflict, either party, any party can file a claim through a court or through an arbitration. So what then will we choose? So that's why this is your job. When you become lawyer, when you become in-house lawyer, practitioners, don't draft something like that. It's confusing. It's problematic. All the time, because when we settle our dispute, we want to have a clarity. Where is the choice of forum? Where is the forum of dispute is to be settled? But like this, it's confusing. Okay. Our first interpretation at the time, we interpret that either party has the right to choose the forum. So we just submit the application to arbitration. We just submit it. But by the time we submit to the arbitration, the secretary said to us, if you do this, there is a high risk that the arbitrators will consider your applications arbitration as inadmissible, tidak dapat diterima. Why? Because the clause is not very clear, he said. Well, in my view, I don't really agree with this guy, but okay lah, let's just follow the institution. So then what we do what the offer and acceptance is all about. What we do about this is we sent a letter to the other party just to clarify, because we are in dispute actually. We are already in dispute and we want to file an arbitration, and that there is a problem with this clause. So we send a letter offering them. This is a letter of offer. We offer them to choose Bani instead of court. That's our recommendation. That's what our proposal was. So we propose to choose. So we ask them, will you agree or not? If you agree, we will go to Bani. If you don't agree, the court is the chosen path, right? But if you don't say anything, if you don't say yes, or if you don't say no, we will consider you as agreeing, as admitting our offer. So what happens? They reply, but their reply is nothing relevant to what we offer. So they talk something else. They reply something else that we don't really care about. So we consider that as acceptance, because you don't really reply our offer. So like we said before, if you don't answer, if you don't have any reply, we will consider you as admitting the offer. So we submit the case to arbitration. After that, based on offer and acceptance, because based on that, we declare to arbitration body that the parties are bound already because they admitted our offer. And this thinking is admitted also by the arbitrator. So the arbitration institution, when they saw the offer and acceptance, they also consider it as binding already. Yeah. And then after that, that was the chairman of Bani. Yeah? And then the second step was the panel of arbitrators. They also consider it as binding, that they have the authority to adjudicate the case, and they decide on it. So that's the example that I want to share. Well, this is an offer is no longer valid if conditions of an offer are not fulfilled, right? In my previous example, the conditions are fulfilled because, like we said in our offer, either you agree, you don't answer, or you disagree. So we really give them the opportunity to choose otherwise. If you don't like us, if you don't like to have a dispute in arbitration, just choose court. But they don't reply whether they want to go for arbitration or to the court. That's their problem, because when they don't reply our questions, they will be considered as admitting to go to arbitration. And it's binding, legally binding. So that's really an interesting case that I experienced, that I think it's good to share it with you. So next is, why is it important to determine when the agreement is formed? Well, to understand about the risk. That's correct, right? I mean, in sale and purchase agreement, if we understand when the agreement is reached, then we also understand when the risk has to pass, between the creditor to the debtor. Or opportunity to revoke the offer. If I understand that my offer hasn't been accepted yet by the other party, and I have to revoke it, I still have the chance to revoke it before it is admitted. Because if it is admitted already, then it is bound. It is binding. I am bound to it. And then the calculation of expiry date, we talk about expiry date kan daluarsa. When we talk about defective will last week, the expiry period for defective will, so if you want to file a claim based on the defective will, whether it is fraud, error, abuse of circumstance, and coercion and everything, that should be before 5 years, because after that you are considered to have accepted your condition. But other than defective will, it is 30 years, right? Generally, it is 30 years unless it is required otherwise by the law. The law requires otherwise for this defective will, which is 5 years. And the other thing is on the hidden defect, cacat tersembunyi. Hidden defect is not really defined will be expired in how many years, but it is regulated as must be submitted as earliest as possible, secepatnya, because it's a hidden defect, right? You cannot see it in your eyes, it's hidden. But when it is hidden and you want to file a claim, you must do it very fast. That's another limitation. So that's why when the agreement is reached is important for this, and the determination on the place of agreement. When everything is made in writing, it will be not an issue, on the place of agreement. Who would care about it? What we want to see is what law is prevailing between the parties, whether this is Indonesian law or other countries' law. Everything is Indonesian law. We don't have like Javanese law or Sumatranese law or Borneo law, Papua law. We don't have it, right? What we have is Indonesian law. So that's it. any Indonesians dealing with Indonesian must be considered based on Indonesian law. Except this Indonesian goes overseas and then has business dealings with foreigners, with foreign entities, then the issue will arise. Yeah, that's why the offer and acceptance will need to show it, and also the agreement that they will sign will need to show the choice of forum, the choice of law. Yeah, the choice of forum is for the dispute, to settle the dispute, but the choice of law is for the which law, yeah, that will be used. There are some theories, yeah, like I said before, this is from J. Satrio book. I think it's a good one, just to understand, yeah, just to get to know it, yeah. We don't really debate it, but perhaps there will be a debate on this, but it's very rare. I've never seen almost a debate about this offer and acceptance, yeah. But it happens from time to time, like I shared with you last week, the case about no, not last week, I think 2 weeks ago, yeah, the case about the misunderstandings between the developer and the promotion company, yeah. That there can be a misunderstanding. So that's why how this theory is looking into it, yeah. So there are statement theory, teori pernyataan, delivery theory, teori pengiriman, knowledge theory, teori pengetahuan, Pitlo's theory, teori Pitlo, acceptance theory, teori penerimaan. So let's start with teori pernyataan. According to this theory, an agreement has existed at the time a letter of acceptance has been written. In other words, the agreement already existed when the other party declared its acceptance. One cannot establish exactly when the agreement has been born. This is the objection, yeah, because it is difficult for us to know for sure and prove when the reply letter is written. So this theory says when there is an offer and there is an acceptance, acceptance is also sent, right? Because if not, then the offerer will not know whether what is the status of his offer. So there is a letter of acceptance, and then the acceptance letter, one cannot establish exactly when the agreement has been born because it is difficult for us to know for sure and prove when the reply letter is written. Yeah, this theory is focusing on when the other party has accepted the offer by writing the letter of acceptance. The agreement is written already. Yeah, so that's why the objection, it's not clear when then. Yeah. Who will know when the letter of acceptance is written? Who will know it? Nobody knows except for the writer. The offerer will not know, right? The offerer will not know. Only the writer of the letter of acceptance will know if he hasn't forgotten already. Yeah. So this theory seems not good. Yeah. So many uncertainty because in an agreement we have to be certain, right? When there is an agreement, when the agreement is reached. Yeah. But this one theory is not very good in knowing and interpreting and deciding also when an agreement is written. So let's move first so that you can understand the difference. Yeah, delivery theory. Now teori pengiriman. Yeah, according to this theory, the agreement occurs at the time of delivery of the acceptance. So there is an offer, acceptance. Teori pernyataan declares that when you write an acceptance, there is an agreement. Yeah. But the delivery theory is different. I can write it, right? I can write it. But when it is formed, when it is born, is by the time I sent it. The agreement occurs at the time of delivery of the acceptance. So delivery, by the time I post it, post office date can be used as benchmark. Well, this is, of course, the examples are not up to date, yeah, but it's still happening. In my case, like I said, I sent proposal through email to my clients, and then they reply, right? And then formality will have to come. So I still send a hard copy engagement letter to my clients. If the clients are located in Jakarta, I almost do all the time deliver it through my courier. So it's a hand delivery, yeah. But for my clients overseas or out of town, out of city, I cannot use my courier, right? I will send it through the post. So that's why it's still relevant until now, the post office, yeah. Even though the post office is not anymore the main medium, yeah, for this, right? Because the main medium is not post office anymore, I think. Yeah, it's more email, WhatsApp, video call, and everything. But for hard copy documents, post office, of course, is still relevant until now. But dealing also with this kind of thing, with email and everything, of course, this delivery theory should be seen as by the time I deliver the email, right? This theory happens when there was no email. There was no email, only letters. So when there was no email, only letters, of course we cannot receive the answer very soon. But the email is real time, right? I send a reply, the other party can look at it at the same moment immediately after I sent it out. So this is, I think, may not be relevant anymore in our age, yeah. But it's good to understand it anyway, yeah. Objection. The downside of this theory is that the agreement is already born, having bound the person who offered at a time when the person who gave the offer himself did not know about it. The downside of this theory is that the agreement is already born, having bound the person who offered at a time, yeah. Why the offerer doesn't know that the agreement is born already? Because he might not know when the letter of acceptance is sent out, right? These two first theories are not reasonable and should be declined. Yeah, like I said, it's not really appropriate anymore in our age. And this is also the argument from J. Satrio, yeah. So it's not really appropriate, yeah, to have these theories anymore. So the third one is knowledge theory, yeah. According to this theory, the agreement occurs when the contents of the reply letter or the acceptance letter are known by the person who offered. So this is getting better, yeah. I'm offering something. The other party writes a letter of acceptance. Yeah, that is the first theory. And then sends out the letter of acceptance. That is the second theory. And then the third one says has to be known by the offerer. So has to be read or known by the offerer. This is getting better, right? So it's getting clearer now. Okay, I'm offering something, and then there is a reply that they agree with this, and this. So it's very clear, right? There is an agreement already. This theory can cause problems, that is, in the event that the recipient of the letter leaves the letter unopened. Now, what if I don't open it? If it is opened, how to determine the timing of opening the letter? So when the offerer will be considered as knowing already know the contents of the letter of acceptance. What if the letter is lost when post is delivering it? Yeah, this is again still in the old age where everyone is still doing everything with letter. Well, yeah, it is still. I mean, in my practice, if sometimes we deal with companies that are very old-fashioned like this, everything must to be through letters, but most of the time the companies are now combining between the hard copy and the soft copy. So let's say that they are signing a letter, they make it in hard copy still, they send it out in hard copy, but they combine it with the delivery through an email. So that's, I think, what is the most common now, but we see that it's getting more to the electronic document only. So no printout, so everything is made electronically and sent electronically. I don't really know whether they are still sending the hard copy, but in my experience as a lawyer, reading electronically, reading electronic document and reading a book, reading a hard copy document is different. In my experience, when I want to review something, really review and really understand the contents, it's a lot easier for me. I am a lot more aware when I do it with the hard copy document. When I only look into the screen, laptop screen, right, and then try to edit, that works also fine. But when it is printed, and then when I have to read again everything, my awareness is higher, and my my ability to review and revise is higher or is better than if I only see it through my laptop screen. So I think it's still good. I don't know. The world is changing so fast. We might someday don't use anymore any big bulky books, because everything is already converted to electronic document. But it's still very relevant, especially in our work, I think, to really look the hard copy. It's more helpful, than just the screen. So knowledge theories is saying that the letter has arrived and it should be known by the offerer, but the objection arises. What if the offerer hasn't looked into it? Well, that happens to me also, actually. After I sent my engagement letter, and then it is returned by my client, I don't really open it anymore unless it is necessary. Unless it is necessary. So I don't open it. My staff open it and filed it, but not me. So this knowledge theory is also not appropriate. Now, Pitlo's theory. According to this theory, an agreement occurs at the time when the person who sends the answer may assume that the person give the answer knows the answer. Nah, this is more like me now. I don't open it because I already know what its contents are. Yeah, because my proposal comes from me, right? The engagement letter comes from me. I deal with it directly. So when it is returned, signed by my clients, well, I know the contents already. Yeah? I don't really have to read. This theory does not take into account whether the recipients in real terms already know the contents. Yeah. I don't really have to actually read the acceptance letter. At the time of the agreement, on the basis of the suspicion that knowledge about the contents of the answer has been born. This is just a presumption, ya, jadi persangkaan. So I presume that the contents of the letter of acceptance must be according to my engagement letter, right? By the time I receive the document and I presume that the contents are the same with my offer, that is the agreement. There is the birth of an agreement. So that is Pitlo's theory. The difference with the knowledge theory is the Pitlo's theory has presumption. Knowledge theory has no presumption. Yeah. So Pitlo's theory is getting nearer to certainty actually. Yeah. When you receive the letter, you don't open it, but you presume that you know it, then the agreement is written. Now, acceptance theory, of course, this is the most common, I think. This is what we do. The widest acceptance by scholars and judges. Yeah, I think the most the theory that gives the most certainty in this case. According to this theory, an agreement is written upon the receipt of the answer. It doesn't matter if the letter is opened or left unopened. This theory does not take into account that its acceptance is lost in its delivery. It never comes to the one who offers, so no agreement is born. Yeah. Well, yeah, these theories are, I think, based on letters, yeah, but it still can be used through email, right? Or through WhatsApp. An agreement is written upon the receipt of the answer. Yeah. So I agree, right? And I sent my agreement through email and received by the counterparty. And that's done, that's enough. So I sent my offer, right? I sent my offer. The other party replied and said, yes, okay, it's a deal. And the yes, it's a deal received by me. That's it. Yeah, whether it's an email, whether it's a letter, whether it's a WhatsApp. So by the time you received it, then it's an agreement. It doesn't matter if the letter is opened or left unopened. So it will mean that if the email is not read by the other party, but he receives the acceptance through an email, yeah, even though he doesn't read it anymore, the agreement is born and the parties are bound. Yeah. Okay, so I'm trying to share these theories. I'm also combining it with my own personal experience, yeah, dealing as a lawyer in a law firm, yeah, because even though it's business as usual, I mean, it's just a standard daily action in my firm, and it's very routine, right? It's a normal thing lah, engagement letter and everything. But there are some tricky parts, yeah, like I explained before. There are times that I sent my offer wrongly, so I have to revise it. And I have to do it before it is admitted by the other party. Yeah, because if it is admitted, it is hard, you cannot change it anymore. Yeah, sometimes uh, one time it also happens that I sent an offer, right, and then I regretted my action because it was too less. Yeah, the legal fees was too less, so I have to revise it. But before I revise it, my prospective client already replied and then said, I accept your offer. Oh my god. Okay, so that's even though I might revise it again, but it's just not ethical to do. Yeah, so I didn't do it. So even though this is offer and acceptance, it sounds normal, nothing special with it. Yeah, but it happens. Some issues arise when you deal with it. Yeah, like my case, for example, I have to revise the offer, I have to withdraw the offer. Yeah, I have to deal with counter offer. Yeah, or my offer has conditions, right? My when I sent an offer, there are conditions that have to be fulfilled. So those are the discussions, yeah, offer and acceptance, the negotiation before the agreement is reached by the parties. Yeah. Now, of course, since we always have a hard copy document, so the offer and acceptance issue after the agreement is signed is no longer discussed, right? Because everything is already recorded in the document. But what if there is no document? Yeah, if there is no document in place, or there is no agreement in writing in place, it will create confusing situation. Yeah, maybe it's not confusing, but it's more what is it? Yeah, it's easier to be argued. Yeah, when you don't have things in writing. Yeah? But if you have things in writing, it is easier to prove. It is easier. It is harder to decline that there is not an agreement.